Salve Magas wanted to make some
Yes, I'm here, my lord.
Mr. Just give us moments so we can.
And my lord, as promised, I'm using an iPad.
Oh, that's nice.
You have promised 20 minutes also.
Yes, yes. I don't promise I'll fill those 20 minutes, but 20 minutes.
Now, just to have an idea of how you're all going to be dividing your submission, uh, Mr. Salve will go first, and then Mr. Paul, then Mr. Jetmani, Mr. Manager.
Supplement.
Just couple of. Okay, give me a few minutes to supplement. No, that's no difficulty. Whoever wants to argue for a minute or two, will hear you. So we'll hear Mr. Salve. Now, just to have an idea of what you're going to be urging, Mr. Salve, you are opposing the reference, or what do you say?
Yes, my lord. My lord, in fact, I'm opening by telling you my submission is that the issues when they were framed, we had mentioned this, but the issues which have now and the events which have now transpired are such that there is no need for this reference. And in fact, the reference would be contrary to the writ petitions themselves. That's what I propose to point out. I open by saying, my lord, we heard yesterday impassioned plea by Mr. Sibal saying how the defection law has failed to curtail defection. And my lord, yes, of course, ultimately no law can completely fill in the gap left by morality. So that's where we are. If Mr. Sibal said the speakers have failed to rise to the occasion, my lord, I don't think there can be any cavil about that, the kind of cases which have come. But also, my lord, equally, this we should always remember this was an anti-defection law, not an anti-dissent law. The challenge and the criticism include right from the late Mr. Palkhiwala, who was one of the great votary of political morality. Always the criticism of such law also used to be that this becomes an anti-dissent law. And that is what this is being converted to today. If I give your lordships 5 or 6 dates, your lordship will see that none of these petitions survive. Unless your lordships, and that is not really even for a bench of 5, unless your lordships come to the startling conclusion that under 142, applications pending before a speaker can be transferred to this court and tried. And that's one of the prayers in one of the writ petitions. Or an even more startling conclusion saying the moment there is a disqualification petition filed, the candidate stands disqualified until he is requalified by rejection of the dissent petition, by the defection petition. But those are not matters, my lord, which 5 of your lordships will refer to 7. What your lordship is today concerned is with the Nabam Rebia problem. I will not take any time reading that judgment beyond saying that there was a serious problem in that case. There is a strong argument that you should not hold speakers to be in suspended animation merely because a removal is pending. But Justice Misra particularly, Malad, brings out the counterpoint. Suffice it to...
Justice Mishra brings out their voice.
The counterpoint.
The counterpoint.
Yes. And I'm only saying this for the reason these are delicate constitutional issues which should be resolved in a fit case where the question arises. Does the question arise in this case? And the answer is a resounding no. And let me tell my lord why. It is, my lord, in our counter affidavit, if your lordship turns to page 494 of volume 1, convenience compilation. What exactly happened and what has happened and where are we today? The only petition in which Nabam Rebia today is a live issue is a petition settled by Mr. Kamath, who perhaps realizing the folly of his ways was argued that Nabim Rebia should be reversed. It's a petition by a group of people against whom the Shinde faction has filed defection petitions. They have come to your lordship saying, because of Nabim Rebia, because we have applied for removal of the current speaker, do not allow him to continue. Now, if they say the judgment is wrong, all they need to do is withdraw their petition. Look at that, Malad, for a minute. Because I think that's what is important to know. In such a delicate constitutional issue, your lordships are embarking on a journey which has no destination. Page 494, Malad, we give the dates.
Of 494 of?
Of compilation 1, volume 1. Malad, PDF page 494. 497, sorry. I hope I've got my PDF pages right.
It's a report. It's a common reply of a
It says convenience compilation volume 1.
It starts on the top as common.
Factual matrix.
Correct. That's that. Matrix मिल गया?
Have your lordships been able to find that?
Where it says factual matrix.
Well, the first sentence in that is in a sub paragraph 7 saying on 21st June 22.
Chief, it is. Yes, Mr. Saleh.
Whose counter is this?
This is Malad from our side.
Right.
21st June 22. It starts by saying it came to the knowledge of the answering respondent. Answering respondent here is the current chief minister, Mr. Shinde, and other members of the Shivsena legislative party. They have used SSLP, the acronym for that. That a minority faction, only 24 out of 55 MLAs, and attended an authorized meeting, passed a resolution to remove the answering respondent as leader and appointing Ajay Chaudhary as the group leader. Then, next para it says on 21st June, 34 MLAs of the SSLP passed a resolution reaffirming that the answering respondent was appointed as a group leader, etc. The resolution was clearly stated that appointment of Ajay Chaudhary is illegal. Now, this is all the wrestling going on with the appointment of the leader of the party. This is all happening on 21st June. Para 10 says on 21st June, 34 members of the Maharashtra Legislative Assembly issued notice under Rule 11 of 179 to Mr. Narhari Zerwal for the motion for removal of the Deputy Speaker. Now, this motion was never carried to fruition. In fact, he continues even today as Deputy Speaker. 24 June 22 is the next event, small 11. Answering respondent came to know that Secretary Maharashtra Legislative Secretariat communicated that a request made by the petitioner to recognize Ajay Chaudhary has been recognized by the Deputy Speaker. So, the other faction's person is recognized as the Deputy Speaker. Then, 22nd June, Sunil Prabhu, claiming to be group leader, issued notice. There were cross notices to each other. Your lordship may drop down to page 501 PDF, para 14. in a meeting held on 22nd June of the Shivsena, which was held by 14 out of 55 MLAs, held at Varsha Bungalow, it was resolved that those members who did not attend the meeting should be disqualified. Now, my lord, the submissions before your lordships have proceeded on the footing that there is a disqualification petition by which all the MLAs will go. What your lordship had not told was only 16 petitions were actually filed. So that's the number in count. Then, my lord, small 15. Accordingly, on 23rd June, Mr. Sunil Prabhu filed a petition under Rule 6 of the defection rules against the answering respondents and a few MLAs for not attending the meeting on 22nd. Now, my lord, please see the next paragraph 16 at 502. And this is why petitions were filed in this court. Forget the Nabam Rebia point. Answering respondent along with few other MLAs received summons on 25th June by Principal Secretary for disqualification, etc., whereby the respondent and others were directed to file a reply to disqualification petition on or before 27th June. Now, my lord, this is even against the rules. You have to give a minimum time. The speaker was rushing ahead. Then, my lord, on 26th July, should be 26th June actually, the answering respondent and other MLAs filed. Therefore, my lord, this was the original petition filed. And in this, my lord, para 18 says on 27 June, this court said we extend time till 11th July. Now, this court did not say that the speaker shall be in suspended animation. By extending the time to file a reply and by compelling these people to file a reply, the court has in fact allowed the speaker to function. Now, we were therefore given time up to by the court till 11th of July. In the meanwhile, my lord, on 28th of June, the Maharashtra asked Mr. Uddhav Thackeray, the chief minister in office, to prove his floor majority. And on 30th June, my lord, a session is convened on which Mr. Thackeray is to prove his majority. On 29th June, Mr. Sunil Prabhu moves your lordships asking for a stay of the session. The court declines it. When the court declined to stay the 30th June meeting, Mr. Thackeray resigns.
So there were two. Actual scenario was this. By our order of 27th of June, we had extended time until the 12th of July.
11th of July. Sorry, 11th July.
The disqualification notice.
12th July.
Yes.
But in the meantime, as a result of the direction of the governor, the floor test was to be held on 30th. In other words, the floor test would take place without the speaker applying his mind to the disqualification.
Correct. Correct. They came to your lordships and said, stay this meeting.
Right.
Your lordship said no. Now, the legality of that meeting is no longer an issue because Mr. Thackeray resigns.
This one.
So there was no meeting on 30th June. So, my lord, the question of the defected or the challenged 16 MLAs voting on 13th June did not arise because there was nothing on 30th June. Mr. Thackeray walked away. So even that question of law doesn't arise. And on that date, I want to give your lordship admitted figures. There are 288 MLAs. The BJP and the independents who support it are 115. With the
115.
Congress and the
115.
115.
All right.
So the balance 173 is the what used to be the Maharashtra Vikas Aghadi. Give or take one or two here or there. Gap of approximately 58. And there are 16 disqualifications. So it was not because of the disqualification pending petitions which tilted the result either way. And Mr. Thackeray saw that and walked away.
So the disqualification was sought against 16 totally.
Yeah, yes. Those are the petitions pending. That's the figure I've not been given.
So these, according to you, wouldn't have made a difference even if their votes were to be excluded.
Even if there was a meeting in which they had voted.
Just factually, 27th June, 22 more were sought to be disqualified. Just
27th.
27th of June, 22 more were sought to be disqualified by the petitioners. Just so that the facts are before you.
I accept my friends.
Any disqualification
Notice was never given of that.
Yes, yes.
1 minute. Any disqualification notice you had given?
Yes.
No.
No notice was given. Please take a.
Petition was filed. Petition was filed. That's all right. The petition was filed for 22.
This was only the initial notice.
My lord, may I?
I'm
So
just
let's
stating the facts.
the facts are clear. Our writ petition related to 16. For the balance 22 petitions may have been lodged, but the speaker took no action. On 27th June. This is when Mr. Thackeray is still chief minister. Now, in a scenario like this, if the chief minister resigns and there is no trust vote, what would have happened on the trust vote? Would these people have changed their mind in view of the pendency of the petition and supported the chief minister? Would they not have supported the chief minister? All those questions don't arise because there was no trust vote.
For their petitions to be really live petitions, that they should have faced the trust vote.
Yes. Then some questions may have arisen
Voted
about
out of
what
office
happened.
on the trust vote.
Yes.
And then you would know who are the actual people who voted
Exactly.
in favor of the trust vote and who was sought to be disqualified.
That's right. None of that ever happened. Now, my lord, 30th June, let me, and my lord, one thing is clear, by now Nabam, Rebia has all become academic. Those 16 disqualifications petitions are still pending. On 30th June, the current incumbent, Mr. Shinde, gives a report to the speaker showing majority. The governor directs a floor test on 4th of July.
On what happened on 30th June?
My lord, the current incumbent goes and moves the governor. He's made chief minister. And on 30th June, my lord, the governor says, prove your majority within 4 days. Now, my lord, in the meanwhile, there was no speaker. Your lordship knows all this rumpus is about the deputy speaker acting. So on 2nd of July, the election of the speaker is filled on 3rd of July.
Notice election of
End of July, the notice for the election.
Now the speaker is fixed for 3rd of July. Your lordship gets these facts in para 26.
Second notice was third election.
Now there are two whips. My lord, one is Mr. Prabhu, who's acting on the Thackeray faction. He says, he issues a whip saying vote for Mr. Rajan Sarvi. And he issues a whip to vote against the confidence motion on 4th of July. In the meanwhile, my lord, Ajay Chaudhary, and this is important, para 28. He is the Thackeray faction appointed leader, issues a letter to the deputy speaker requesting him not to consider the vote cast by the members against whom disqualification is pending. Then, my lord, election of the speaker is held. Now, my lord, all this is academic because the speaker's election is not under challenge before your lordships.
That's also which
Actually, it all boils down to this, that they didn't face the trust vote, according to you.
Correct, my lord, as far as the first round is concerned.
And the total number of petitions in respect of which disqualification was sought was 16. There was
Correct.
disqualification was qua 16.
Now, your
22
lord,
came in later, no notice was issued by the speaker, and then everything was overtaken by the events.
events, and today you do not have any assertion before your lordship saying, if you take even the 22 plus 16, 38, the election of Eknath Shinde is vitiated. Because by the time he was elected, my lord, after Thackeray resigned, political events then changed. My lord, people who were on one side shifted to the other side.
that's
Mr. Salve,
Yes, my lord.
Also show us the prayers in the writ petition.
I was immediately going
Has
there.
been filed, it has been filed against the decision of the governor on 28th of June 22 to hold the floor test.
Page, my lord, that is writ petition 493. I was immediately going to take your lordship there. This is in the convenience compilation. It's the first writ petition.
Ultimately, what happens is really the two orders, the two judicial orders really seal the fate of the
Correct, my lord.
first order of the 27th,
Yes, my lord.
which says that, you know, we give you time, extend time until the 12th
Yes.
to submit your reply on the ground that the speaker had given only 2 days time. Therefore, the first order says time until the 12th. Then when they came back to the court, challenging the convening of the trust vote on the 30th, our court said no, no stay. So really speaking, everything, it was these two orders ultimately
And,
which
but
affected
my lord,
the
there's a
first
third.
order had the consequence of
Yeah.
not allowing the speaker to go ahead with the disqualification petitions
Of 16 people.
before the 12th.
Of only 16 people.
Of 16 people. And the second order had the consequence of ensuring that the trust vote takes place on the 30th.
Correct. Except the
They
trust
knew,
vote.
I mean, the Uddhav Thackeray faction knew that without a decision on the disqualification petition, the trust vote was sealed then.
My lord, there also I'm saying the gap was, no, my lord, the gap was 16. No, that's not correct. That is not correct because, my lord, the disqualification petitions which were deferred by your lordship as 16, they had 58 majority.
I beg your pardon. Come again.
The 16 petitions were adjourned.
Right.
The gap was 58 between the BJP and the Agadi.
Yes.
So if you take the 16 out,
That's not the point. Eknath Shinde became the chief minister.
first Mr. Thackeray resigns, then Eknath Shinde becomes chief minister. It's not in the reverse sequence.
So what?
Now, there is no legal, if Mr. Thackeray had contested the election, the effect of which had been in any manner impacted by the non-decision of the defection petitions, some question of law may have arisen.
Yes.
So, my lord, saying put him back means your lordship will then have to declare his resignation illegal. That's the only way he can come back. Now, my lord, let us see what are the petitions before your lordships. Please turn to page 99 of the first petition.
PDF page 10. He said we are not challenged.
I think Mr. Sibal doesn't realize his mic is on. I can hear everything he's talking to his juniors.
Oh. I'm not saying it. I'm not revealing a state secret.
Not yet.
All is the light away.
My lord, I was waiting.
Mr. Sarve is just washing you. $99, is it?
Yes.
99 of the same affidavit, of the same compilation?
Yes, my lord.
Yeah, first.
PDF page 102, perhaps.
493, serial number 1 of the bookmarking of the conveyance.
Two?
Yes, it's bookmark 1.
102.
Is right. It's bookmark 1.
Yes, the bookmark one. You got it, yes.
Yes. And at page 102, because I have 3 page numbers, but I think PDF is 102.
This is writ petition filed against 36. Okay, I get it.
Yes, 30th June. My lord wanted to know the
Yes,
challenge
yes.
to the governor. Pass an appropriate order or direction quashing the decision of the governor to invite respondent 4 to take oath as chief minister. Pass an order declaring illegal proceedings of the Maharashtra Assembly heard on 3rd July. Pass an appropriate writ held on so and so.
Also, election of speaker. Just read that.
Yeah,
Yes, and also challenge the election of the speaker.
Yeah.
Now, my lord, most important is D. And I submit D is, none of this has Nabi. I'm only answering whether your lordship needs to refer Nabi Arabim to 7. Look at D. Call for records of all pending disqualification petitions against so-and-so pending before so-and-so.
Yes. This is what I was asked. So then,
3 of your lordships will hear these someday and decide whether this extraordinary relief can be given. And whether your lordships can say we will become the election tribunal. The 3 judges or 2 judges of Supreme Court for the first time will try a disqualification petition. But I think it's... So this is, my lord, one petition. This is, I believe, writ petition 493. The second, my lord, is the challenge to the trust vote, which is...
Yes. This is the trust vote challenge.
which is writ petition 470. I think that is number 9 on the bookmark. Page 351. Petitioner whip of Shivsena member of the Legislative Assembly is constrained to move the court on 29 June, challenging the completely mala fide unconstitutional illegal actions of the governor. The governor, by communication of June, which was received as in complete defiance of the fact that the court is seized of the issue of disqualification in a desperate attempt to allow the members who have incurred disqualification a safe passage to hold a floor test on 30th June. His point was that your lordship is considering the validity of the disqualification proceeding.
Is
Yes, Mr. Salve.
Yes. Now, my lord, as far as Nabia Rabim is concerned, before I show my lord two more writ petitions, then I'm almost done. It could have applied in two situations. Had there been a trust vote on 30th, and there been an injunction in place, and I'm assuming that your lordships may have been influenced by Nabia Rabim judgment to give time to 11th of July. Let's assume. The
So
page,
when would have Rebia applied if there was a trust vote actually on the 30th?
and if a court had restrained the speaker from acting, the court only said give time to 11th of July. We are, my lord, today on the 15th of February 2023, the petitions are still pending. And there was a reason why the speaker has done nothing. My friends remind me, because there was a set of cross disqualifications filed against the other group who voted against Eknath Shinde. And they came and complained saying that the new speaker will rush ahead and disqualify. And there was an understanding, keep everything in freeze. Because now there is a speaker, there is no deputy speaker. So obviously these will stand transferred to the speaker unless the speaker's appointment is set aside. So, and they said we have challenged the speaker. So everything is on hold. So Malak, this Nabia Rabim had no role to play in all the events that have transpired. No court had issued a mandamus based on Nabia Rabim, which is an appeal before your lordships. And your lordships have to consider if this judgment was wrong and this mandamus had not issued, then how do we restitute? None of that ever happened. I can understand, my lord, if we had gone to the Bombay High Court following this judgment had stayed the speaker, then the events transpire, appeal comes, your lordship says, no, this Bombay High Court judgment is wrong because we are going to reverse Nabia Rabim. Now how do we restitute? None of that happened. My lord, one thing I will say, when the disqualification law was inserted, there was a clause added originally, which said if you are expelled from the party, you lose your seat. There was a criticism that time, my lord, it was the late Mr. Rajiv Gandhi's government, which had, we know, my lord, had an overwhelming majority. One of the largest ever in parliament. There was a criticism saying, is this a measure that now we have everybody inside the barn, we want to lock the barn door? He dropped that clause. The clause was dropped from the provision when it was finally made, brought into the constitution. Mr. Ashok Sen was law minister that time. So, my lord, this should also, the anti-defection law also is not a weapon for a leader who has lost faith of his numbers to hang in, because there are layers of political morality in each of these. And my lord, it is best your lordship stay away from all that. Because these are very complex questions. Now, my lord, the second writ petition is bookmark number 9. My lord, Justice Narasimha asked me, where is the challenge to the 30th June governor's action? This is that writ petition.
Prayer.
Yes. And in this, my lord, the prayer, I'll give you lordship in a minute, is on page 400, sorry, 408.
377, 374, 375 or 377 of the PDF.
Yes, my lord, 377 of PDF.
Challenging the communication of the governor.
That's right. Now, this has clearly become academic because, my lord, on that communication, no meeting was held.
Yeah, I think, look, there should be no trouble. Yeah.
Then we have item 10. Bookmark 10.
It is and it isn't academic, but for the communication of the governor, they wouldn't have resigned.
Maybe, but my lord, if your lordship set aside that communication, what happens?
Ultimately, Uday Thackeray, he resigned because of the communication of the governor to hold the trust vote.
Correct. My lord, if he had gone,
he knew that, well, if I have to face the assembly the next day,
yes,
without the disqualification petition being heard, he doesn't have the numbers.
No, my lord, that again is wrong. 16 disqualifications alone were stayed.
Yeah,
11
that's what you made. 16 plus 22 also you said if you exclude.
38, there's still 58. Secondly, my lord, as a court, political events, your lordship is right. But as a court, if he did not face the trust
I mean,
vote,
what you're saying is that there was never any trust vote, so why challenge the communication?
I mean, it's academic because there was let's the communication goes, what happens? The meeting doesn't go.
It's academic in the legal sense, you're right.
In the legal sense. Correct.
It's all part of one
And
intrinsic.
that's why, my lord, that's why in my respectful submission, it is hazardous for your lordship to be drawn into.
Right. Anything else, Mr. Sarve? Should
Yes.
we
Just want to finish the record.
20 minutes by about 20 minutes.
Yes. My lord, the two more writ petitions remain. I just want to.
Yes, which are they?
My lord, that is, I'll just give your lordships the bookmarks. Item 10, that is challenge to Mr. Gogavle.
479.
But what is important, my lord, and I finish with this, is item 11 by the petitioners.
Item 11.
Yes.
That is Sunil Prabhu.
Relying on Rebia and on which the speaker has held his hand because there was an understanding that nothing will be done. And now they are saying this is wrongly decided. Page 412, my lord, your lordship has page 412.
Page?
412.
Yes, and the prayer is at 461.
Yes. No, before that, please just see 414.
414.
Yes. There is a paragraph saying secondly.
It's true because we are saying that no.
Now the petitioners are saying this judgment is wrong. But there has to be some rule of holding people to what they have come to court.
It will never apply to.
414, you said.
Second.
Ye kahan hai?
Page
411 otherwise.
411.
411 on the right side, Maharaj. I believe the PDF page is 411.
That's right.
This is their petition, right?
Yes. Which relies on Rebia Rabim. Now you can't say this is the law, so on this I'll get a stay, but I'll get up and argue that this law is wrong.
In this petition, in the counter affidavit, did you say that Nabam Rebia is wrong?
No, Maharaj. we were careful. except the roles are reversed. Maharaj, I will end by...
Survey, the bottom line is,
Yeah.
Nabam Rebia becomes right or wrong based on, which side you are in which political situation.
Maharaj, I will only end by...
Somebody or the other is supporting it. The same people are supporting Nabam Rebia. The same people oppose it, depending upon which way.
I've said what I had to say about this, Maharaj. This is not a fit case to decide these issues. I will only close, Maharaj, with a story which Mr. Parasaran once told us. He told the Constitution bench of your Lordship's court, saying in Satyug, a man was a tenant of a farm. He found a pot of gold. He went to the owner and said, "This belongs to you because I only have the farm for cultivating grain." The owner said, "No, God willed you to get it. That is why you discovered it." So they had a dispute. They went to the king, by which time it was Kalyug. So contrary to their pleadings, as he explained, the tenant said, "This is mine because I found it." And the owner said, "No, this is in my land, therefore it is mine." So that is what is going on here.
And ultimately, king said it.
Seizes power, gets the pot of gold.
What the king said is what I want to persuade your lordships to hold. Don't waste my
For
time.
any treasure, we have an act, right, in India. We have an act of 1972. The Treasures Act. When a treasure is found, it belongs to the treasury.
Yeah, it was.
The constitution.
I was only going to close by saying, your lordship should do what the king did. Tell both of them, don't waste our time. That, my lord, is my submission.
All right. Thank you, Mr. Sare.
Lordship, please.
Thank you.
After Mr. Call, Lord, since I was not here, my Lord, when your Lordships were inquiring who will argue, Lord, I would assist your Lordships, Lord, for 15 to 20 minutes.
All right.
With some different angle, my Lord, which I may, Lord, project.
All right.
I'll deal with the merits of the submissions. Now, my submissions, of course, are going to be, my lords, that Nabam Rebia requires no reference to a larger bench. It lays down the correct law. There is no conflict with Quixote. Nabam Rebia actually considered disqualification of MLAs. It is wrong to say it was only concerned with the powers of the governor. I'll show that. I'll also show how the word freeze in para 191 of Nabam Rebia is read completely out of context. And once that is read with Justice Mishra's judgment, wherein clearly it is said, and in what context it is said, is that under 102, 103 and 191, 192, there are provisions of disqualification either by the speaker or disqualification by virtue of the provisions mentioned in the Constitution in consultation with the governor or the president, as the case may be, and after seeking an opinion of the Election Commission. The freezing word that was used there after referring to Dr. Ambedkar's comments in the Constituent Assembly debates was meant to say that even during those debates, whether it was for the removal of the vice president or otherwise, what was considered of immense importance was the strength of the House on the date that resolution was then moved and not present in voting. So the argument sought to be given to your lordships was that was only in the context of a majority qua the strength of the House. And how could that be taken to mean freezing the strength on the date the notice is issued? What is not pointed out to your lordships is, and which is of course apparent, is that when these Constituent Assembly debates took place, and when these provisions from 179 downwards were all inserted, there was no 10th schedule. And as your lordships have time and again said, that let no provision of the Constitution ever be fossilized. to a stage where any emerging situation or problem is not dealt with. Let it be evolutionary, let it be transformative, and it must deal with the new challenges that emerge. And it was keeping this in mind, what the court used the word freeze, and I'll show that in Justice Mishra's judgment as well, was to say that as far as notice is concerned, that whole debate, that notice followed by resolution, followed by motion, are all procedural requirements. My learned friend gave examples. Suppose a notice is given on the last date. Suppose after notice, no resolution is moved. These are hypothetical problems, imaginary problems, and constitutional bench judgments are not referred to larger benches on the basis of hypothetical problems that you're imagining. Those are procedural issues. They can always be taken care of. But what your lordships have time and again reiterated and said is that even when a disqualification petition is pending, every MLA has the right to vote, whether it was Shivraj Chauhan, whether it was Bishnoi, whether it was judgments thereafter. So you have had the right to vote. What Nabam Rebia dealt with, that's with the coming of the 10th schedule, the moment a notice is given, the speaker, if he has to act towards unconstitutional ends, will not wait for a motion or a resolution to be moved. He will get into the act right away by disqualifying, and that is what happened here. And the disqualification that they were talking about, the vacancy they were talking about, were only with respect to the powers exercised by the speaker, not with regard to the other disqualification under 191 read with 102, 103, which is purely the domain of the governor or the president, as the case may be, in consultation with the Election Commission of India. They were referring to vacancies, as Dr. Ambedkar said, with the strength being of the then members. So the object and the spirit was take it in totality. It was that totality and composite pool of the then members, of course, minus if someone has died, unfortunately, if someone has been declared an unsolvent, if someone has been declared of unsound mind, and the president and the governor have held them to be disqualified. 191 doesn't say that all of those people will be included. That's a separate provision under 191 and 102 read together. The purpose was that any person who will be disqualified by virtue of the speaker exercising his powers as a tribunal under the 10th schedule must await the decision of the speaker to first prove his own majority, and which Nabam Rebia said is based on both ethical reasoning and constitutional reasoning. The ethical reasoning was that it would be highly improper on your part to go ahead with something and alter a majority and then put your own vote as to the confidence of the House, whereas if you're confident, prove it at the shortest possible time and then take on these petitions. And then they dealt with the debates and said that on the date the notice is issued, you are put to notice on that day that the procedure for motion and resolution will follow. And that is where the mischief may lie. And to curb that mischief on that day, you must stop, the clock must stop ticking on that day as far as disqualification is concerned. Because in para 193 after that, the court goes on to say that if tomorrow a person is wrongly disqualified, he has the remedy by way of judicial review to go and get it corrected. But in the meantime, if a speaker wins his vote of confidence, that is not subject to judicial review. Where will that be corrected? And that MLA would have lost his opportunity to vote. And this is, my lords, given the fact when your lordships have time and again in those series of judgments have said, irrespective of at what stage a disqualification is pending, you cannot stop an MP or an MLA from voting. That is the constitutional scheme. And in repeated judgments from Shivraj Chauhan downwards, that is what your lordships have held. So we are dealing today with a situation where Nabam Rebia's para 191 is read and the word freeze is read completely out of context. The Constituent Assembly debates are not seen in their true letter and spirit. And an impression is given to your lordships that Nabam Rebia got it completely wrong. That is the broad perspective of my lords. I'll deal with each of those issues. But please keep in mind, firstly, on which Mr. Salve also briefly addressed your lordships, on what led to these two petitions.
Actually, Mr. Kaul, it's a tough constitutional issue to answer for this reason, that the consequences of both positions have really very serious ramifications for the polity. If you take the Nabam Rebia position, Nabam Rebia position says that once the speaker is, the existence of the speaker itself comes under a cloud by the issuance of a notice. And Nabam says that then the speaker should not decide upon the disqualification until his own continuance meets the ratification of the House. The consequence of that is then to, as we've seen in Maharashtra, is to allow the free flow of human capital from one political party to another.
So
That's
well
the-
put, Mullah. So
Right.
well put.
So that's one end. On the other hand, now look at the other one. Suppose on the other hand, you say that notwithstanding the fact that the speaker's continuance is placed under cloud by the issuance of a notice, that he can still decide the disqualification notices. The consequence of that then is that essentially, where the leader of a political party has lost his flock or her flock, right? He can still hold them down to his group, though as a matter of real politics, he's lost his flock or her flock. So adopting the other extreme would mean that you are really ensuring a political status quo, though the leader has effectively lost his or her leadership over a group of legislators. That's the other way. If we completely overrule Nabam Rebia. If we hold Nabam Rebia has also very serious consequences for, because then it's a free flow.
Manoj, I'll deal with that flow as I develop my arguments, I'll deal with free flow.
Ultimately, both ends of the political spectrum are, both ends, whichever way you accept it, has very serious consequences.
Manoj, as I said, let me deal with it. I've just begun, let me deal with it. I like.
The factual scenario.
Both are not desirable in a way. That even Mr. Sibal would accept. I mean, we are looking at it as purely constitutional.
Maharaj, I'll leave that to when I make the argument on merits. Maharaj, because I don't want to, Maharaj, interfere at this stage. Your Lordship is right at first blush. But Maharaj, the politics of it has not to be decided in the House. I'll demonstrate that, Maharaj. The politics of defection in the House is not to be decided in the House. You have to go back to the political party, and that argument I'll reserve for the merits, Maharaj. I'm just, Maharaj, indicating that to your Lordships. Maharaj, here there is no split in the party. We are talking about a split in the House, which has been rejected under the 10th schedule, because the only way out is merger. This way, Maharaj, you can split any party and form any government, and the human capital will flow, as your Lordship said. So the other extreme may not apply in the context of a split in the legislative party. I'm just indicating. And there's the other thing I just want to say.
But both, as I said, Mr.
Yes.
Sibal, both in that
I will in response
both
argue that also.
both have compelling sides to the.
Yes. The other thing is Eknath Shinde.
Actually, the second one actually.
Says lost the plot, it means in the legislature, not otherwise. This is the issue.
We'll hear it.
And the other thing is, Maharaj, Eknath Shinde was one of the 16, and he has become chief minister. And 164(1)(b) he can't.
Let me in my own way, so my learned friend will have his chance. Manoj, it's important to know what led to the order of 27th. Mr. Salves touched upon it. In my own way, let me explain to your lordships what led to.
27th came about because a notice of 2 days was given.
Manoj, I'll just, yes, your lordships are right. I'm just adding to it. And overwhelming majority gives a notice on 21st to the deputy speaker for his removal.
For the
Removal of the deputy speaker on 21st of June.
Just fine.
Is it 21st or 22nd, Mr.
No, no, that's important. That's why I said 21st of June. That's a very important fact. That's why I'm getting some factual clarity before I come to the legal issues. 21st of June, an email is sent as per the rule, which is Rule 18, specifically informing through an advocate a petition signed by 34 MLAs, an overwhelming majority informing that we have lost the confidence in the Deputy Speaker. The Deputy Speaker has filed an affidavit in this court to say that that email was received, but since it was from an unknown address, I did not recognize it. 22nd of June, a hard copy with a stamp with 34 MLAs is again there and provided for. Now on 21st of June, it is important for your lordships to know what had happened. On 21st of June, my lords, a hopeless minority within the Shivsena, and that's a progress.
When?
On the same day.
22nd.
21st.
Right.
Because I'm going to address that whole point that this is a defection, it's a split, it is an inter-party dispute is what we've been saying. You have been repeatedly referring to split, clause 3 which has been deleted, defection. That is not our case. And what your lordships and repeated judgments have held, that internal dissent within a party is the essence of democracy. Merely because there is an attempt to change a leader in a political party does not mean it comes within the purview of the 10th schedule and becomes a case for disqualification either under clause 3 as it stood or a case of merger if you don't merge with 2/3. Because we are not talking about leaving the party and merging with any other political party. Our contention right through, and this is what I argued before this honorable court on the earlier two hearings, we are the Shivsena. There is no question of we represent an overwhelming majority of the party, of the legislature party in this case, and the political party as we claim, which is being decided by the EC. When these people had come before your lordships and said, stay the election commission proceedings. Your lordships have said, how can election commission proceedings be stayed at this stage? That is a powers under the symbols order and the constitution solely given to them. As far as the legislature party is concerned, out of the 54 or 56 MLAs, 40 are here. So when this whole argument which is presented before your lordships, and that is why I said I'll deal with it when the time comes, on free flow, we are not talking about a free flow at all, to any other party at all. We are talking about an internal dissent within the political party, where an overwhelming majority has said we no longer have faith in Mr. Thackeray, which is an internal dissent within a political party, which every political party is entitled to have and must encourage.
So 21st, you said first that an email by 34 MLAs stating that confidence was lost in the deputy.
Right, and two other events, my lords.
On the same day.
On the same day happened. And those two events
It was on 24th, not 21st. At least state the facts correctly.
24th.
Email was on 24th, not 21st. You stated it is on the 21st.
My lords, the deputy speaker's affidavit says 21st it has been received.
Email is on record.
It says notice.
Why make a wrong statement?
Just a minute. My lords, his affidavit says on 21st, a notice allegedly signed by 39 MLA was handed over to the office of the deputy speaker. Now, this is the deputy speaker's affidavit.
That's not
and
true.
I'm sure my learned friend will have his chance. Please don't interrupt. All that I'm respectfully submitting, my lords, now is that three other events
Yes.
happened on the 21st of June.
Yes.
First is, my lords, a hopeless minority of MLAs.
How many?
Please, my lords.
How many?
24 out of 55 MLAs met and passed a resolution removing Mr. Shinde as leader and appointing Mr. Chaudhary as the leader. This resolution also recognizes that Mr. Prabhu has been appointed as a whip previously. Now, no notice of this meeting is given.
That's 21st again.
21st of June. no notice of this meeting is given. On 21st itself, my lords, the majority within the party of 34 MLAs then, which of course later became about 40, 34 MLAs then reaffirms Mr. Shinde as leader of the Shivsena legislature party as appointed on 31st/10/2019. It appoints Mr. Gogawale as the chief whip and cancels the appointment of Mr. Prabhu with immediate effect. So these two events simultaneously happen. Undoubtedly, the majority vote for Mr. Shinde to be retained, that there is no dispute that the 24 were a minority. And on the same day, a notice is sent to the speaker. And on the next day, a hard copy with a stamp is also received on the 22nd in the office of the deputy speaker. So really, my lords, 21 is really for purposes of a complete narration, but even on 22nd, a hard copy had been received.
Page 494, what Mr. Sarve was reading.
Yes.
Page 494, just maybe you can just look at that because that gives us a complete picture of what happens in those. That's a crucial period.
Yes, yes, my lord.
Page 494 of convenience compilation.
Yes, yes.
That's, you'll get it at PDF page 497.
Right, my lord, right.
Just have a look at it. You can just quickly run through it. It'll take a minute actually.
Yes. So would your lordships want me to start right from the beginning of 494?
Yeah, the Roman 7.
Roman 7. On 21/6/22, it came to the knowledge of answering respondent and other members of the SSLP that a minority faction of SSLP, that is only 24 of the 55 MLAs, attended an unauthorized meeting and passed a resolution to remove answering respondent as the leader of the SSLP and appointing Ajay Chaudhary as the group leader of SSLP. A true translated copy of the resolution dated 21/6/2022, passed by 24 out of the 55 MLAs illegally removing Mr. Eknath Shinde as leader of the SSLP and appointing Mr. Ajay Chaudhary as leader of the SSLP is annexed herewith and marked as so-and-so. On the same date, that is 21/6/22, 34 MLAs of the SSLP passed a resolution reaffirming that the answering respondent who was appointed as group leader of Shivsena legislature party on 31st/10/2019 continues to be the leader of the SSLP. The resolution clearly stated that appointment of Ajay Chaudhary was illegal, void and inoperative. Further, it is the said resolution, Mr. Bharat Gawale was elected and appointed as the chief whip of the SSLP and appointment of Mr. Sunil Prabhu was resolved to be cancelled with immediate effect. A true translated copy of the resolution dated so-and-so reaffirming their answering respondent as leader is annexed herewith. Members of the SLP wrote dated 21/6/22 to the Honorable Deputy Speaker informing him that the majority have reaffirmed the appointment of the answering respondent as the group leader of the Shivsena legislature party, therefore not to recognize Mr. Ajay Chaudhary as the leader of the SSLP for the 14th Maharashtra Legislative Assembly. Then 10, thereafter on 21/6/2022, 34 members of Maharashtra Legislative Assembly issued notice under Rule 11 of the Maharashtra Assembly Rules read with 179C, Constitution to the Deputy Speaker so-and-so to move the motion for his removal from the office of the Deputy Speaker and requested him to refrain from discharging functions of Deputy Speaker, Speaker of the Assembly from immediate effect. A true copy of so-and-so of 34 MLAs is annexed herewith. On 24/6, my lords, would your lordships want me to continue?
No, I read that. Yes.
So, my lords, all that I am saying is that when this was done and the notice of removal is given, after that, my lords, what happens is that I am given contrary to the rules. Contrary to the rules which provide for under Rule 18, 7 days time to reply on 2 non-working days, time to reply to the disqualification notice.
That is the 25th, right?
That is on the 25th of June 2022. And 25th and 26th were weekend. And on 27th June.
Now, the notice by the speaker of giving 2 days time was given to how many? 16?
Yes, yes. On 27th June, my lords, again, it's important to know why did we come and what was the order that was passed.
Yes.
May I, my lords? We came by a direct 32 to this honorable court for 3 reasons. Principles of natural justice, my lords, and your lordships in a series of judgments from Algarapuram to Scheller to Balachandar have held that if there is a violation of principles of natural justice, those are one of the rare cases which even the internal proceedings of the House can be interfered with, leave aside an adequate notice not being given for a disqualification notice. So relying on all those notices, we came saying that you give us 2 days instead of the minimum 7 days which the rules provide for. One, those very MLAs, their houses and families were being attacked in Maharashtra. They said, we have no way to even arrive into Maharashtra at the moment. Our lives in our danger, and the only remedy which lies for us is an Article 32 petition. And of course, Nabam Rebia was also referred to, that the assumption of jurisdiction by the Speaker is completely prohibited, because the Speaker, as per from para 188 onwards, the Supreme Court in Nabam Rebia has said that you cannot initiate any proceeding the moment a notice has been given. So we took all the grounds. When the order was passed by the Honorable Supreme Court on 27th of June, the Supreme Court only went by the principle of natural justice and gave more time after hearing the arguments, did not injunct the Speaker from proceeding with the matter. Now, after that, my lords, on the 28th of June 2022, leader of the opposition, Mr. Fadnavis, went to the governor and requested him to hold a floor test. The governor on 28th of June issued a communication to Mr. Thackeray directing him to face a floor test on the 30th of June 2022. 30th of June. On 29th, my lords, Mr. Prabhu files a writ petition in the Supreme Court saying stay the floor test. And it is at that stage, my lords, that we came before and said a floor test can never be stayed, because your lordships have time and again said that a floor test brooks no delay. A floor test is the litmus of democracy. A floor test is where the dance of democracy takes place, and we will never ever injunct a floor test from taking place. That's the surest way for a set of MPs or MLAs or a government or a chief minister to prove his majority.
Our court declines to it.
And the court declines it. Within, it was a late night hearing. By about 9:30, the order is pronounced, and within 10 minutes, Mr. Thackeray resigns. So a chief minister or a leader then, who right through knew he did not have the majority within his own party, had no majority therein, resigns. And as Mr. Salve pointed out, even if those 16 MLAs were removed, even then, if he could, he would have proved his majority on the floor of the House. He doesn't face the floor test at all. So right through this exercise of disqualification, removal of whips, etc., has been carried out by a hopeless set of minority within the party. And one of our principal contentions right through, and that is when your lordships, if your lordships decides to proceed with the matter and not refer it to a larger bench, will be that the whip which was issued, because what was the allegation when they filed the disqualification petition? The disqualification petition was filed against us to say that when we convened those 2 meetings on 21st of June and 22nd of June, you did not were present, and you have thus voluntarily given up your membership of the party, which was one of the grounds under the 10th schedule. Our answer, again, as I said, that's on the merits on a later date, was one, for 21st, you give no notice. For 22nd, you keep it in the same evening at 5 p.m. And thirdly, it is given by a party, the whips are being issued by a party, by a person who has been removed on the 21st by a majority. Mr. Prabhu on 21st of June admittedly has been removed by us, who are the majority within the legislature party. And he could not have issued a whip. So they clearly know they were in a minority in the legislature party. So while they were trying to stall the EC proceedings, They came up with the ingenious argument that no, it's the political party which we looked at, not at the legislative party alone. Your lordships rightly at that stage said, who constitutes the political party is a matter which the EC will decide. Which are the talukas, which are the districts, what is the membership, that will all be seen in the light of Sadiq Ali and all other judgments that will be done. We will not interfere and act as a court of first instance and start deciding what the EC should decide. As far as the speaker is concerned, he deals with the legislature party. He deals with the whip of the legislature party. He deals with the leader of the party. That's what a speaker always deals with in parliament or in the legislative assembly. Now, as far as that legislature party is concerned, you are in a hopeless minority. As on date, 40 are on this side. So this whole, the nomenclature being used repeatedly is to say defection, clause toppling, clause 3 is being defeated, clause 3 no longer exists. That is not the case. The case is we represent the Shivsena. We are the majority within the legislature party. So there is no question of any free flow occurring here in this matter. Your lordships are right. There could be a situation. That's not the case here factually. More importantly, my lords, even after that, and this is important for your lordships to know, on 3rd of July, Mr. Rahul Narvekar was appointed as elected as the speaker. At 12:01 p.m. At 12:02 p.m., certain MLAs belonging to the same hopeless minority issued a notice for removal of Mr. Narvekar as the speaker. On 4th of July, 2022, the House reaffirms its confidence in the newly elected speaker. So, my lords, even going by the Nabam Rebia test, this speaker has proven his majority on the floor of the House. The speaker gives notices to both the parties as of those petitions which are pending. Because the matter was before the court, it was agreed between the parties that the matter will not be precipitated. And an argument is made before your lordships that the speaker is biased and he's sitting for 8 months on the petitions.
That's all.
There was an understanding in the court that the matter will not be precipitated any further. Everyone will hold their hands, except the Election Commission, which was never meant to hold their hands, but they kept arguing that the Election Commission was meant to hold their hands. Till we showed to your lordships there was no order injuncting the Election Commission and they were not participating in the proceedings, and your lordships dismissed their injunction application against the Election Commission.
What is the date of notice for removal of the speaker subsequently? 3rd of July or?
3rd July
3rd of July.
at 12:01 p.m.
That's the very day when the speaker was elected.
Yes. So, my lords, after the lordships are right, 3rd is a notice. 4th, he proves his majority. And after that, on 4th, again a confidence motion is moved to remove the speaker. Lordships must know what has been the conduct and who is the party doing what they are doing in the matter. Because the impression being given to your lordships is this is murdering democracy. This is leading to horse trading. This is leading to a situation where MLAs are being allowed to defect to another party. Governments are being toppled. But the point which is to be addressed and is not being addressed, that if within your own party there is dissent, and as the leader has lost the confidence of the legislature party, how can that leader ever continue as the chief minister of a state who doesn't even enjoy the bare minimal majority within his own party? Leave aside the confidence of the House. Here was a man who had lost majority within his own party. An overwhelming majority was against him. Leave aside the confidence of the House. And the impression sought to be given to your lordships is as if on that date, had that order of 27th not come, the order of 27th based on Nabam Rebia facilitated the toppling of the government, read with the order of 29th, and because of that it fell, and Nabam Rebia is wrong law, and thus the matter should be referred to a larger bench. That's the whole impression being given to your lordships. I'm not denying that in my petition under 32, I took Nabam Rebia as a ground. I'm entitled to, my lords, because the Constitution bench has said that you cannot proceed. And if a speaker chooses to proceed, I'm entitled to take it. And I'll tell you, lordships, what the difference between that and Quixote was. They sought to argue this also, then saying that Quixote says no one will come at an interim stage. How could this court on the 27th interfere when Quixote has said that at the interim stage the court will not interfere? The straight and clear answer to that was, my lords, Quixote deals with a situation where there is an assumption that the speaker has the jurisdiction. The question is, the speaker is proceeding with something of which he has jurisdiction, and the court should not at the initial stage interfere. We came with a petition where the very assumption of jurisdiction by the speaker was contrary to Nabam Rebia. Now, till Nabam Rebia is referred to a larger bench or set aside, my lords, it's good law. I'm entitled to come and say his very assuming of jurisdiction is contrary to a constitution bench judgment of the Supreme Court, because the words used in 188 are he cannot proceed. He cannot even take a step after a notice is issued. That is what the law is. That is why I filed a 32. That is why I raised issues of natural justice and a 32.
Mr. Kaul, that once you invoke Nabam Rebia in your writ under Article 32, it would be putting a gloss on the situation now for you to say that the order of the 27th of June was not based on Nabam Rebia, was based only on the ground that there was a violation of the principles of natural.
My lords, may I with respect?
In fairness, the order doesn't say what the basis of the order is, but you invoke the jurisdiction of the court.
My lords, I cannot make
you are entitled to it.
I cannot make an incorrect statement that I did argue it in the petition.
That's right.
I am not for a minute even suggesting that I did not argue it during oral hearings. I did. But the fact remains is, my lords, I am still entitled to say that ultimately, my lords, your lordships has said the order is what it says. The order of the court clearly only goes on one premise.
There is no restraint on the speaker.
My lords, if Nabam Rebia was relied on, then there would have been a restraint on the speaker. Otherwise, Nabam Rebia has no meaning at all. Nabam Rebia does not talk about 2 days extra being given or 5 days extra being given. That is not Nabam Rebia. That is your lordship's entire line of judgments in Algapuram, Scheller, and Balachandar. Those are that if natural justice is violated, in any case.
Equally, the order doesn't say that you file your reply on the 2nd of July.
Yes.
The order says you will not file your reply. You will have time until the 12th.
Yes. So, my lords, all the time.
If it was only an order based on natural justice, it would have said, all right, the speaker will not pass any order before the 2nd of July.
My lords, may I with respect
say that? So obviously the reason was you had also invoked Nabam Rebia, and you, as you fairly say, that was your case. That was your case. You were entitled to it.
My lords, I may be wrong, but as I read the order, as I see it, the court said we are giving more time to file a reply. And that is where the order ended. Till this order does not injunct the speaker in some way with either proceeding or passing an order, according to me, Nabam Rebia, I think in all humility, I am entitled to say, was not the basis of the order passed on 27th of June, for the simple reason that the natural consequence of Nabam Rebia or reliance on Nabam Rebia will be that the speaker will not proceed with the matter. I said, Nabam Rebia is not on any other issue at all. Nabam Rebia is not on natural justice. Nabam Rebia is only on the fact that should the proceedings under 179 and 10th schedule are concerned, if there is a notice under 179, then the 10th schedule exercise of jurisdiction is brought to a standstill till 179 is decided. Is all that Nabam Rebia is about.
Eventually, Mr. Kaul, on facts, your case is very clear. Your case is, look, on the, once the trust vote was called by the governor, you moved the Supreme Court. You means they moved the Supreme Court, seeking a stay on the trust vote. 29th, our court says, no, there will be no stay on the floor test in the House. Rightly so, because there can't be a stay on floor test. That's the ultimate litmus test, as we have always said. Thereafter, the only course of action for them was that, well, face the House and then decide how much of the vote is ultimately influenced by the presence of the persons who were sought to be disqualified. They obviated that by resigning. They never faced the House.
I could not have put it better, and why I'm emphasizing.
That is really the point which we will have to deal with.
Why I'm emphasizing on this is
because ultimately you don't face the House at all. That is something we will hear.
Why I'm emphasizing, and my lords, I'll also deal with Nabam Rebia and show some of those judgments and the provisions and Constituent Assembly debates. I'll just come to it. The reason I'm emphasizing on this is, my lords, because this whole impression is given that it is because of this order that defection, toppling of governments, things against constitutional morality happened. That's completely wrong.
The process had process had commenced probably on the 21st itself.
Right.
It's obvious from the meetings which were being held by both the factions.
Right.
There was
And
a-
my lords, it is no one's case that when the resolutions were adopted on 21st, 22nd, undoubtedly has a majority of MLAs within the party. They now try to get out of it by saying, no, let's look at the larger political party, not the legislature party, which in any case, the lords has said is for the EC to decide. And we'll get into those issues at a much later date because those are complex issues. Which taluka, which district member, how many members, that's a separate issue.
Mr. Skolby, I think we've got the hang of the facts now. The facts have been...
So, my lords, let me now go on
Now
to
go directly to Nabam.
Nabam, and my lords, I'll cite Nabam in a few other judgments and make good my submission, my lords. Yes.
We'd also like to hear you on whether a reference to Nabam is a live matter in this case. There is something which we would like to, because we are that's an area which we are open. You can argue it at two levels. First, you are entitled to argue that don't refer Nabam in this case. And two, that Nabam, in any case, according to you, lays down the correct position in law.
So don't refer. Sorry.
So don't refer.
So don't refer, and it's no longer a live matter.
The second point
Is what your lordships are saying.
Yeah.
That was correct.
Once you say that it is correct, there's no question of...
Yes, yes. Very well.
I think your point that Nabam, the reference doesn't arise, you have already dealt with in your statement of facts, because that's why you've highlighted the fact.
Not only that, my lords, I want to show to your lordships, because it fell from my lord, the Chief Justice, in the proceedings. It's free flow. I want to dispel that impression and show what was Nabam all about. Under what circumstances Nabam was. What were the Constituent Assembly debates? No. At length arguments were addressed on that. And that is why
That is to be decided in a disqualification.
as Nabam is concerned, now I'll just come to the relevant paragraphs and I'll read a few paragraphs from the majority decision and also Justice Mishra's separate opinion on the matter. Now, the point was this. The word freezing did not mean that whatever is the then strength, irrespective of disqualification under 102, 1 or 191.1, or a member is dead, is frozen. It has to be read contextually. Justice Mishra deals with it and says that, look, the approach we are adopting, that the powers exercised by the Speaker under the 10th should, in the meantime, he should hold back till 179 is decided, is in consonance with the provisions under the Constitution which exist, which are, and he relies on Article 181 and Article 189 to say, let's see a scenario in 181 where he can vote on a resolution against his removal. But if it's a tiebreaker, he cannot vote because he.
Justice Mishra puts it really on this ground that when the Speaker exercises the power in qualification under the 10th schedule, I think he has to act impartially. It's in the nature of a judicial function.
Absolutely.
Therefore, anything which is liable to affect your credibility in the discharge of a judicial function must therefore govern when he
I bow down.
when his own authority to act as a speaker is called into.
I bow down.
The logic.
But he adds a very important argument also to it by saying that the provisions of the Constitution as they stand indicate and support exactly what we are saying, and that was in the mind of the framers, because 181 entitles a speaker to vote in a resolution against him, but not in a tiebreaker. Because in a tiebreaker, then he would be a judge in his own cause. But under 189, he cannot vote except in a tiebreaker. So Justice Mishra draws that distinction and says even the provisions as they exist before the 10th schedule was introduced did indicate that the speaker in these matters must reflect a position of complete impartiality and avoid any form of conflict of interest. I'll read those paras to you, Lord.
Just those 2 or 3 paras. Let's if you,
yes, and my lords,
why don't we look at the 3
yes,
provisions
and just one
go to those 3 or 4 paras that will really cut short everything.
Yes, and then my lords,
it's the heart of the matter.
Yes, and then one more thing, my lords, before I come to Nabam Rebia, just one more thing. Nabam Rebia also discusses the fact, and Justice Mishra discusses it, that all the provisions that you're now referring to were framed and adopted at a time when there was no 10th schedule.
Yes.
If 10th schedule was in place, and I'll rely on some judgments to say that no provision of the Constitution ever should be fossilized if there are changing circumstances, emerging problems. Your lordships will take an evolutionary interpretation to deal with that problem. The problems that are being placed before your lordships to say Nabam Rebia are wrong are completely procedural. To say on the last day of the session, a notice is given, then there is nothing for 6 months, or a notice is given but no resolution is moved. These are hypothetical problems that you're thinking of that can't be the basis of Nabam Rebia being referred, my lords. I'll show rules which do provide for an expediency, which do provide for an expeditious disposal. B, those checks and balances your lordships can always consider if there is a scope after a notice of misuse. But there is a difference between saying that after a notice is issued, there could be a scope for misuse by a resolution not being moved, or a notice being issued on the last day, and to say that the law laid down by Nabam Rebia is not correct. Those procedural misuse, if at all, today these are just imaginary misuses which may occur, could occur, can't be the basis, according to me, for a 5 judges decision being referred to a larger bench. B, if that were to be so, your lordships in an appropriate case can deal with it. That you can't hang on to it and not decide the matter indefinitely, especially when the rules itself provide for 7 days notice, decision as early as possible. Those indications are there in the matter. But what you're seeking to say is that right in the meantime, there can be no hiatus. There was great emphasis laid on the word there was no hiatus in a constitutional functionary. Now that constitutional functionary who assumes jurisdiction under 10th schedule, 2 dangers lie. One, and the arguments ought to be made before your lordships were, that 179 and 10th schedule are separate, and thus one cannot be interfered with the other. There are 2 dangers with that argument. One, the very continuation of the speaker under the 10th schedule and assuming jurisdiction as a tribunal is dependence on his legitimacy to continue, which is being decided in a 179. Secondly, the danger, the moment a notice is issued to the speaker, and your lordships have time again from Kyoto to Nabam Rebia said, that these are realities of the time. Speakers are also political appointments. These are words of the Supreme Court used, and we can't ignore the fact that there may be a scope for misuse in these matters. That speaker who has to misuse or work towards an unconstitutional end will not wait till the date a resolution is moved or a motion is moved in terms of 179 read with Rule 11. He'll start acting as of yesterday on the date the notice is issued. And if in the process he disqualifies all the MLAs whom he feels will be inconvenient to his interests, the entire pool changes. And that is where Dr. Ambedkar, when he referred to the then 10 members of the House, said that you can't restrict it to the majority of present and voting. It should be majority of the then members. What was the reason behind it? The reason behind it was that the strength of the House should be reflected. Now, naturally, the argument in 191 can't be that by using the word freeze and the then members and strength of the House, Nabam Rebia has ignored that so many people may die, may be disqualified for other reasons. That's not what Nabam Rebia says. It only says that 191 subclause 2, 191 and 102, my lords, consciously make a difference between disqualification, as I had respectfully submitted, on grounds mentioned with the governor or the president taking the decision in consultation with EC, and 2, referring to the Lok Sabha, to the 10th schedule and the speaker of the Lok Sabha.
Mr. Kaul, why don't we do this? Why don't we look at the we'll allow you to sort of create a theory based on the bare text of the provision.
Yes, yes.
You go to Nabam and
yes, yes,
let's
yes,
look at the provisions
yes.
first.
So, my lords, let's
look at it independent of Nabam, and then see whether Nabam is correct or otherwise.
Yes, yes.
Because let us first look at it as a
so my lords, what I'll attempt to do is I will just show to your lordships 191, 192.
Yes.
Paramateria is 102, 103 for the Parliament. Then I'll show 181, 189. And I'll straight away thereafter come to the paragraphs of Nabam Rebia.
That will be logical then.
On this aspect, my lords, before I...
You can read it holistically, taking within its sweep even 10 schedules.
Yes, yes. Yes, my lords. So please have... My lords, I'll start with 191 since we are dealing with an assembly instead of 102, 103. Please have 191.
Because we read it.
A person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or Legislative Council of a state A, if he holds any office of profit under the Government of India or the Government of any state specified in the first schedule other than an office declared by the legislature of the state by law not to disqualify its holder. B, if he is of unsound mind and stands so declared by a competent court. C, if he is an undischarged insolvent. D, if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance or adherence to a foreign state. E, if he is so disqualified under any law made by Parliament. Explanation: for the purposes of this clause, a person shall not be deemed to hold the office of profit under the Government of India or the Government of any state specified in the first schedule by reason only that he is a minister, either of union or of such state. 2, a person shall be disqualified for being a member of the Legislative Assembly or Council if he is so disqualified under the 10th schedule. So 10th schedule, my lords, firstly is a separate provision altogether. Then 192. If any question arises as to whether a member of a house of the legislature of a state has to become subject to any of the disqualifications mentioned in clause 1 of Article 191, the question shall be referred to the decision of the governor and his decision shall be final. Before giving any decision on any such question, the governor shall obtain the opinion of the Election Commission and shall act according to such opinions. Yes. Now, my lords, please have, this, my lords, was for the proposition that when the word freeze, the then members are considered, and the argument sought to be made is Nabam has got it completely wrong, because a person could have died, a person could have been disqualified for other reasons, etc. Everything is frozen on that date. That's not the context. The context of the word freeze is that anyone who can be disqualified by the speaker under the 10th schedule will not be disqualified, and the then members of the House or the composition of the pool of the House at that stage will be dehorse the exercise of power under the 10th schedule.
Now, which is the next provision you want us to see?
Yes, my lords. The next provision is 181. Is the provision? This one, two. My lords has 181, Article 181.
Yes.
The speaker or the deputy speaker not to preside while a resolution for his removal from the office is under consideration. At any sitting of the Legislative Assembly, while any resolution for the removal of the speaker from his office is under consideration, the speaker, or while any resolution for the removal of the deputy speaker from his office is under consideration, the deputy speaker shall not, though he is present, preside, and the provisions of clause 2 of Article 179 shall apply in relation to every such sitting.
Start with
Let's see 179.
Yes, ma'am. I'll start with 170. I'm sorry, madam, I should have started with 170. Vacation and resignation of and removal from the office of the speaker and deputy speaker. A member holding office as speaker or deputy speaker of an assembly, A, shall vacate his office if he ceases to be a member of the assembly. B, may at any time by writing under his hand address, if such member is the speaker, to the deputy speaker, and if such member is the deputy speaker to the speaker, resign his office. And C, may be removed from his office by a resolution of the assembly passed by a majority of all the then members of the assembly, provided that no resolution for the purposes of clause C shall be moved unless at least 14 days notice has been given of the intention to move the resolution. Provided further, whenever the assembly is dissolved, the speaker shall not vacate his office until immediately before the first meeting of the assembly after the dissolution. And now, my lords, may I read 181 again, Your Lordships?
Yeah.
The speaker or the deputy speaker not to preside while a resolution for his removal from office is under consideration at any sitting of the Legislative Assembly, while any resolution for the removal of the speaker from his office is under consideration, the speaker, or while any resolution for the removal of the deputy speaker from his office is under consideration, the deputy speaker shall not, though he is present, preside, and provisions of clause 2 of Article 180 shall apply in relation to every such sitting as they apply in relation to a sitting from which the speaker, or as the case may be, deputy speaker is absent. The speaker shall have the right to speak in and otherwise take part in the proceeding of the Legislative Assembly while any resolution for his removal from the House is under consideration in the Assembly, and shall, notwithstanding anything in Article 189, be entitled to vote only in the first instance on such resolution or any other matter during such proceeding, but not in the case of an equality of votes. Now read this, my lords, with 189. Article 189, my lords. My lords have 189?
Yes.
My lord, the Chief Justice says.
Yes.
Voting in houses, power of houses to act notwithstanding vacancies and quorum, save as otherwise provided in this constitution, all questions at any sitting of a house of the legislature of a state shall be determined by a majority of the votes of the members present in voting, other than the speaker or chairman or person acting as such. The speaker or chairman or person acting as such shall not vote in the first instance, but shall have and exercise a casting vote in the case of an equality of votes. So, my lord, Justice Mishra relies on it to say that these provisions also are an indicator of the constitutional trust, avoidance of conflict of interest, and any decision which directly impacts him. 181, where there is a tie, he cannot vote. In other cases, he cannot vote, but if there's a tie, he can vote. And he said these are all indications, and it's the same principle that we are adopting. When under the 10th schedule, where he is to decide on the people who may tomorrow vote against him under 179. And if he takes a decision to consciously disqualify them between the date of the notice and the resolution under 179, he would have altered the pool.
181 flips the
Yes.
So 181 says you can speak and vote, but not in the case of an equality. 189 says that the speaker can vote only when there is
of a tie.
Of a tie.
Yes.
So the normal rule is that the speaker can exercise the right to vote when there is a tie, but where the vote is on whether he or she should be removed, then he can't
Right.
exercise his-
And that is what Justice Mishra relies on to say as one of the grounds that he derives his strength and support from. Apart from the larger picture of constitutional trust and conflict of interest, those are the provisions that he relies on to come to the conclusion that he does in the matter. So that impartiality of the highest standards is maintained. And conflict of interest in any form, even the remotest, in my I'm giving this is actually a problem. And that is exactly what unfolded in this matter. That the moment a notice is given for removal, you start diluting or altering the composition of a pool of people who will vote for you or against you under Article 179 of the Constitution. So if you've already succeeded in what you were to do, will be a fait accompli.
If you look at it purely in a literal, we've never interpreted the Constitution just literally, it's an organic document. But if you interpret Article 181 in a very literal sense, it places only one disability on a speaker. That disability on a speaker is that once a motion for the removal of the speaker is under consideration, the speaker shall not preside on the motion where his removal is under consideration. But while he cannot preside, he can participate and vote, but not exercise a casting vote.
Right.
Now, 181 therefore seems to indicate that the mere fact, we'll now read whether that is affected by the 10th schedule, how the 10th schedule affects it. Because 181 was brought in before the 10th schedule came in.
Right.
191 was amended to bring in 191 too because of the 10th schedule.
Right.
181 seems to suggest that save and except for this disability on a speaker who is facing a motion for removal, namely that you shall not preside you are entitled to speak and vote, but you will not cast a casting vote. Save and except for this disability which is cast under 181, the Constitution places no other disability on the speaker.
But that disability, my lords, is where a direct conflict of interest as far as his own removal is concerned. That article only deals with his removal.
Therefore, that now we are imposing, as Justice Mishra also imposed an implied limitation on the power of the speaker. Now, he develops that implied limitation on the basis of the 10th schedule. Because there's nothing in Article 181. 181,
Yes, my lords, absolutely.
Justice Keher reads that in, which Justice Mishra also in passing refers to by the use of the expression the then members of the assembly. Right. And that is probably the weakest link in the argument. Presiding
restrictions are.
Mr. Paul, if we can read a principle, into 180, 189.2, right? And into 189, 181.1. If we can read, what is the constitutional principle? The constitutional principle is a principle of constitutional bias. Namely,
Incorporation of a
that when
principle
your,
bias.
right, when a motion for your removal is under consideration, you shall not preside as a speaker, right? Because if you preside, then you will channelize the debate, you will channelize the conversation, the dialogue in parliament, in the state legislative assembly. So it incorporates the principle, the rule against bias.
Rule against bias.
So 181 is a constitutional incorporation of the rule against bias.
One,
But it also incorporates the principles of natural justice by saying that, look, you can certainly speak, but it dilutes a little bit of the principle of natural justice by saying you can also vote on a motion for your own removal. Normally, you can't vote on a motion for your own removal. It allows him to vote on a motion for his own removal, subject to the caveat that the casting vote which is given to you in your capacity as a speaker, you will not vote. You will not wield on that occasion.
right. So, my lord,
So it's a very delicate,
yes, but,
it's a very beautifully formulated principle.
but delicately balanced.
No, it
keeping
takes
in
care
mind-
of all aspects of the matter.
Right.
It takes care of the bias part of it, which is an institutional principle. At the same time, it takes care of the individual right of the speaker also, giving him an opportunity to speak.
Now, what Nabam does is, by sourcing these, though it doesn't say so in Justice Mishra hints at it, by sourcing these principles in 181.2, what Nabam does it extends it a little bit by saying that if the vote on your removal as a speaker is liable to be affected by the exercise of your power under the 10th schedule, then you can certainly affect affect the outcome of a motion for your own removal by exercising or not exercising your powers under the 10th schedule. So therefore, don't exercise your powers under the 10th schedule so long as the vote for your own removal is not is really fluid.
But the real question is that when does that obligation commence upon the speaker? That is on the basis of the notice or prior in point of time. At what time it comes? That becomes very crucial. Even if we take this interpretation.
Mr. Paul, you have to make submission on under consideration.
Under consideration.
At what stage it can be said to be under consideration?
Part taken.
Huh? Taking up the that can be said to be taking under consideration.
Correct.
Now, my lords, may I address it?
See, the 170, the proviso to 179 says 14 days notice has to be given.
That's right.
Of the intention to move the resolution. Does the prohibition attach the moment an intention to move a resolution is given within the meaning of the proviso to 179? Or does the prohibition attach when the motion is under consideration within the meaning of 181.2? And then, how do you, as Brother Shah said, what is under consideration? Does under consideration begin even when the notice for moving the resolution is given under 171, under the proviso to 179? Or does it become under consideration only when the House has a motion for debate? You can reflect on it at lunch. We'll come back at
Malad, I just want to say, Malad, that a lot of arguments have been made on facts, Malad, which I not.
But now this is, we are not.
I hope, Malad, that because all the facts that my learned friend mentioned, Salve mentioned.
Rebutting on what arguments we
No.
opened with on facts.
I never made any argument. Lordships
I
told
think you
me.
did a sizable argument.
Facts we are going to where, because Malad, a lot of these facts have been misrepresented and against the record. So I don't want to go into that, Malad. I mean, we are talking of only on the issue.
I'm not getting into it. I thought substantial arguments on facts. Grateful.
Mic check. 1, 2, 3.
First is 101.
Mic check. 1, 2, 3.
First is
Mic check.
70.
Mic check.
75.
1, 2, 3.
75. Same. Once you disqualified.
Mic check.
75.
Yes, the same. Same thing as 164.
So this is 91st amendment.
That's right.
101 and 102.
This green, this is unmuted.
I told my
Yes.
Friends, before I come to Nabam, before lunch, when your lordship rose, what your lordship had observed was that under Article 181, a fine and delicate constitutional balance is maintained by the framers of the Constitution. So on one hand, you will not preside, you will not vote in a tie. You could vote on any matter connected with the removal, but not in a tie, and you will not preside so that you don't channelize, as my Lord the Chief Justice said, a debate in a particular direction. That's the fine balance in this case. But please keep in mind that this balance under Article 181 is one in a scenario where the entire House is involved. The Speaker is not all in all. The entire House is involved. Even there, quite contrary to 189, they say in a tie, you will not vote. Under the 10th schedule, when the Speaker acts as an adjudicatory body, deals with an issue as a tribunal, he's the all in all in that situation. So how will a fine constitutional balance dealing with a scenario under 10 be maintained? And that is my respectful submission, that if, as the words as used by my lords, that if constitutional violence and bias are to be avoided, as it is avoided in under 181, is to be avoided under the 10th schedule. The date has to be the date of the notice. And that is another thing directly dealt by Justice Mishra in his judgment, saying that those days between the date the notice is issued and the 14 days to move a resolution, the entire composition could be changed of anyone who is inconvenient. And what happens thereafter? Whereas in the case of an MLA who is then later disqualified, he can come and get it rectified as far as judicial review is concerned. But what happens that he misses that opportunity to vote? There is no judicial review of a removal. What is also important is there is no vested right to continue as a speaker. If you are removed as a speaker and you win the confidence of the House again in a scenario, you can be re-elected as a speaker. You don't lose your membership of the House. Whereas as a member of the House, if you are disqualified unfairly by the speaker who wants to alter the pool so that he can win his election under, he can defeat a resolution for his removal under 179, the bedrock of democracy is shaken, because not only do you lose your right to vote in Parliament, there is a whole constituency which goes unrepresented. So we are talking about a much greater harm even if we are balancing the two. You're dealing with a person, a constituency going unrepresented, an elected representative losing his right to vote, which shakes the very bedrock. A speaker can always get re-elected if he has and he doesn't lose the membership of the House. So all that I am respectfully submitting, my lords, is that the potential harm of the constituency being left unrepresented and a government which is not enjoying the support of the members being established, because if you've removed half the members who are inconvenient to you, something far more dangerous and damaging to democracy can happen. And that is why in para 191, Nabam Rebia says that if he establishes his confidence, wins the vote of confidence, then he goes on to decide. And as far as the members are concerned, if they are unfairly disqualified, thereafter the court can set us aside. But you can't avoid your resolution for being removed by first disqualifying the members. It is in that context. So 181, when it maintains a fine, delicate balance, it is not dealing with the 10th schedule scenario at all. Now in 10th schedule, my lords, I take it. Suppose as it's being argued, it should be at the date of motion or it should be date of resolution. That's being argued that if at all someone has to hold their hand, it should be at that stage. Now, my lords, these are all matters of procedure. 14 days notice, resolution, motion under the rules, whatever you may call it. But the speaker who intends to change the composition of the then members of the House will not wait till that stage.
What is the point of time at which the disability on the speaker?
Well, my respectful submission is, and that is what I am now coming to Nabam Rebia, is on the date of the notice under 179 subclause C proviso. When that notice is issued under 179 subclause C proviso, is when the disability comes in. Because as Justice Mishra deals with it, that the moment you express your intention to remove a speaker, he can start acting. He doesn't have to wait till the resolution is moved. Till the motion is moved.
But that will have very serious ramifications for the reason that a person who moves the motion, you require only one person to move the motion.
Right.
There's no threshold required. Second, the person who moves the motion, who moves the notice, who issues the notice may not move the motion at all.
So
so this would be capable of grave misuse. That is to prevent the speaker from exercising any power. You have to only say any power to decide the disqualification.